Thank you for watching our webinar on private lending in IRAs. Today we'll talk about a number of different types of private lending within the IRA arena, mostly focused on using IRA funds to make third-party loans and do other things. We will touch a little bit on potentially an IRA getting a loan, which is a little bit more rare circumstance, but we will touch on that a little bit today. I'm the presenter. My name is Scott Maurer. I'm the Education and Marketing Director for Advanta here in Tampa Bay. Also a licensed attorney. I've been so for a couple of years, but we don't do legal work, or at least I don't do legal work for Advanta as a company. I started with the company back in February of 2006, handling at that time a lot of the transactional paperwork. So I've seen a lot of these different types of loans and different things done over the years. I've transitioned within the last couple of years doing more of the education and marketing side, getting out and speaking about the availabilities and different things you can do within a self-directed IRA. But I still do some transactions from time to time, so I do still see a lot of unique and different things done within an IRA. And I really feel that private lending is an arena where a lot of possibilities exist for someone to be creative and do different things and hopefully drive a higher return to their retirement account. Advanta, we do act as the administrator for the IRA account. We are not legal, tax, or investment advisors, though that's something that's very important to understand at the outset. When we look at a transaction, we look to make sure things are properly vested and that to our knowledge and it's not obvious on the facts, on the face of the documents that something is prohibited. But ultimately deciding whether something, in this case maybe a loan from your IRA, is a good or bad idea, you really should consult with your attorneys, your accountants, other financial advisors, and certainly need to do your own due diligence on individuals or businesses that you're lending to, or if you're lending on a secured loan, making sure that the collateral underlying the loan is sufficient. That's not something that Advanta is going to do. We, again, don't give legal, tax, or investment advice. Again, quickly just recapping our agenda for today, talk specifically about the types of private loans that are out there, spend a little bit of time on disqualified persons and prohibited transactions. That is very important when you're deciding, when you're making a loan, if you're looking at dealing with certain individuals or certain types of assets and making sure something will be legal for the IRS. Talk about the advantages of private lending, get into some case studies, and we'll talk a little bit, as I mentioned, about non-recourse borrowing for an IRA. Rather than the IRA lending money to a third party, actually having the IRA obtain financing, usually for the purchase of a piece of real estate. Not something that's done fairly often, but we will touch on it briefly within this presentation. Private lending can take a number of different forms. Certainly we have individuals who've done traditional mortgages where the IRA is lent for the purchase of somebody else's primary residence, and the IRA then holds a 15 or a 30-year amortized loan. But more often than not, it's something maybe a little bit more favorable to the IRA investor. Could be a traditional mortgage, but there's a 5-year balloon. There may be interest-only payments, things like that, that again favor the IRA a little bit more to get a higher return back to that account. I've seen short-term transactional funding, kind of just you have your money lent out for a period of 1, 2, maybe 3 months. The loan is paid back, maybe at a higher interest rate, but it helps bridge that gap for someone else on the other end. That can certainly be done within an IRA as well. Unsecured promissory notes, these are certainly probably your riskier route to take when doing a loan with an IRA account. Because there's no underlying collateral, really the only recourse you have against your borrower is the fact that they signed a promissory note to your IRA account, and you'd have to sue based on that. So a little bit riskier note, but certainly is legal to do within an IRA. Certainly people do some equity participation, joint venturing on deals, typically, again, involving real estate. You could also secure your note, maybe not with a traditional mortgage where there's a piece of real estate or a home securing the collateral, but using other assets like livestock, farm equipment, automobiles, notes or memberships in an LLC can also be used as security for a private note. Then we'll talk here now about the kind of the transactions, the prohibited transactions within an IRA. What are your restrictions when investing in an IRA? Well, there's 2 types of investments that are not permitted within an IRA. You can't hold life insurance, and you can't hold collectibles. And collectibles would include your antiques, alcohol, artwork, Certain stamps and coins, if they're of a collectible nature, as opposed to certain gold, silver, and platinum coins that are allowed because the value of the coin is based on the value of the actual metal, not on its rarity. These are the types of investments an IRA is limited to making. You're not permitted to make. Cannot buy life insurance, cannot buy collectibles. Now, collectibles can also include automobiles, so that'll kind of come into play when we start talking about something else a little bit later in the presentation, so just keep that in mind. The bigger area, though, where we deal with, that we deal on a day-to-day basis with our clients that have questions or have potential issues is when the IRA is looking to deal with a disqualified person. And that would include, well, for an IRA, the disqualified persons are the IRA owner themselves personally and their spouse, as well as any parents, grandparents of the IRA owner, any lineal ascendants, and also lineal descendants, kids, grandkids, and also any spouse of a lineal descendant. So a son-in-law or a daughter-in-law is also considered a disqualified person for your IRA account. And then also any business or entities that are owned or controlled by one of the above. It's important when you're thinking about the prohibited transactions and thinking about disqualified persons, your IRA is a separate legal entity from yourself personally. So that entity dealing with one of these individuals and transacting with would be a prohibited transaction and not allowable under IRS guidelines. So to have a prohibited transaction, you would have your IRA and a disqualified person and a transaction between the two. And transaction I typically defined as when you have two parties with competing interest, a buyer and a seller, a landlord or a tenant, or in this case, a borrower and a lender. So if your IRA is the lender and a disqualified person is the individual looking to borrow the funds, that's going to be what is prohibited. And see the note there at the bottom of that slide. There is no caveat to this rule. IRAs cannot lend money to a disqualified person or a disqualified entity under any circumstance, regardless if the term is fair market value. It's the same deal that an individual would have gotten or received at a bank. There is simply no caveat. It's prohibited in all circumstances with disqualified persons. Some other things to think about. Brothers and sisters, aunts, uncles are technically not disqualified persons. So being that they're not on that list, your IRA could transact with them. Your IRA could lend money to one of those third parties. We just kind of caution you, you probably would like to, or you probably should deal with them on a fair market basis. If your brother or sister went to Wells Fargo or some other lender and were able to obtain a mortgage loan with certain terms, your IRA lending to them should probably follow those same terms. If you're starting to discount the note, give them a better deal, that's probably where you're starting to get into what could be looked at as prohibited. Using a middleman between your IRA and a disqualified person is also prohibited. So going back to that previous slide, your IRA under no circumstance can lend to yourself or to a son or a daughter-in-law. You can't have your IRA lend money to your friend Joe and then have Joe lend the money to one of those individuals. That's considered a step transaction and is also prohibited under IRS guidelines. The step transaction doctrine is usually applied by the IRS in the intent format. They're looking to see what was your intent for all the different steps that happen. If your intent was for your IRA funds to get to your son or daughter, regardless of the number of steps you put in between, it's going to be prohibited. And the step transaction doctrine is applied by the IRS, and typically the burden is on the IRA owner to prove that it was not their intent for that kind of ultimate disqualifying transaction to occur. Having your IRA lend money to a friend and having that friend lend the same amount back to your IRA, again, this kind of falls in line with the step transaction doctrine again. Are you looking at getting around those rules by using a couple of different circumstances? I don't know that this is necessarily prohibited, but it's just something to think about. If I made a loan to my friend Paul and lent $50,000 to him in 2012, and then 2015 comes around and Paul decides he's going to lend me money from his IRA, there's a lot of time in between. The circumstances have changed. Probably wouldn't be something to be concerned about or be prohibited. But if I lend money to Paul and Paul, next week lends money from his IRA in the same exact amount on the same terms, would look a little suspicious. Kind of last thing to remember, one other thing to consider at least, having your IRA lend money on a note and having that note secured by something that is prohibited for your IRA to hold, like a collectible. Again, if you're in this kind of bringing up that automobile example that I mentioned a minute ago, if your IRA cannot own, for instance, an antique car within your IRA account, if you lend money to someone, they sign over a promissory note, and as collateral for that note, they also give you a lien against that collectible car. If that person doesn't pay on the note, you might have an issue trying to collect what's unpaid because your IRA could not exercise the lien and actually repossess the car because now you're holding a prohibited asset within the IRA. So you have this issue of how would you ultimately collect? Would you have to assign the rights in that lien to a third party and let them kind of, in a sense, foreclose on the car and take it back? So it's kind of a lot of issues, and that's why we typically wouldn't recommend using a collectible or an automobile or something like that as a security for your note. It doesn't necessarily make it prohibited yet because really the investment is the loan, but you could have an issue later on down the line if your borrower is not paying you back. Certainly, why would an individual look to invest in private loans? I think one of the biggest reasons that our clients would do it is you're getting to kind of set the terms with your IRA. If your IRA is the lender, then you get to decide what terms you're willing to lend money out of your account to that borrower. So if you're setting those terms and you have sufficient collateral and sufficient security for your notes, you're almost setting the rate at which your IRA is going to grow each year. If you're lending money at 7, 8%, or maybe 10 or 11, that's the rate of return that's coming back to your IRA account each year. Another reason that some individuals favor holding a note over perhaps, for instance, owning real estate, you might have less liability. Certainly some of our clients do invest in real estate, and that's also fine to do within the account. But if there is a trip and fall or a lawsuit relating to that property, it's potential that the IRA could be sued or be subject to some liability. If your IRA is invested simply as the note holder, you certainly might be much better protected in the event something happens. It also can be a very low maintenance asset. Again, if your IRA owns real estate, the IRA is paying for the bills, it's receiving rent, you're kind of making sure tenants are properly coming in and out of the property. With a mortgage or a private loan, you're just making sure that that gets paid once a month, and then you're happy. You know, as long as your payment is received, there's nothing else for you to do. And when you're establishing the note terms with your borrower, again, if it's your IRA, you get to act as the bank. Decide which terms you want to include, what those terms will actually take the shape of. So if someone's looking to borrow money from your IRA, you're deciding how much you're willing to lend, what your interest rate you're going to charge, what the length of that term is. Again, it could be a 15-year mortgage, it could be a 5-year balloon. That's all going to be up between you and your borrower when deciding how you're going to handle that investment. Certainly could include prepayment penalties. It could be an interest-only loan. Another thing we've seen quite often, well, not say often, but a little more frequently lately, equity participation, lending money to someone who's doing a rehab project, doing other improvements where when they sell the property, rather than pay you a set rate or a set return, they're willing to give you a certain percentage of profits back in to your IRA. So that could be something else that you look into. Well, we'll switch through now and kind of just finish up the presentation with just a number of different case studies to illustrate not only kind of some of the different things people have done, but also illustrate the process involved with investing your IRA into a private loan. In this first example, we have Paul, who has some money in an IRA, looking to lend it out as a first mortgage. He's definitely wants some security there. He's not interested in an unsecured note, wants the security of a piece of real estate backed with the IRA. If the IRA has to foreclose and isn't being paid back, at least he has an asset to recover against. He works with a mortgage broker, and again, you don't have to work with a mortgage broker. Some of our clients do work with third parties who help place their money into particular loans. Again, Paul's going to make sure that the person he's lending to and the property he's lending on is sufficient and acceptable to him. And the terms of his note, he does a $120,000 loan with an 8% interest. It's a 5-year balloon, and so it's a monthly payment of $800. It's an interest-only loan. This is basically just like a CD, but obviously with a much better rate of return. He could also have amortized this loan, maybe his return would be a little bit lower. He could amortize it over 5 years so that the borrower does get some equity in the property when they ultimately sell it or pay him off. But that's the terms of his deal. As far as the process involved, Paul, as a client, is going to open up and fund his account, fill out our application paperwork, transfer funds in from an existing IRA. Again, he finds the loan and analyzes the terms. Again, doing his due diligence on not only the borrower, but also on the property that he's lending on. Advanta is not going to do that due diligence, not going to do that research for him. Paul makes the offer basically to the borrower. Here's what I'm willing to lend. Here's the terms at which I'm willing to lend my money. Submits a purchase authorization form to Advanta telling us, my borrower's name is Joe Smith. I'm lending $120,000. It's 8% interest, etc. We will review the documents, make sure that they're properly vested, make sure his IRA is listed as the borrower, or as the lender. And ultimately, Paul, as the client, will read and approve all of the documents for us. He's going to actually have to initial off on each page that, yes, these terms are acceptable. Again, we're looking simply at the wording and making sure the terms, as Paul has told us, match in the documents, but we're not reading all the other legalese that is contained in those notes and mortgages. Once Paul has approved the documents, we'll wire the funds to the title company, the mortgage gets recorded, and the purchase is completed. Now going forward, the borrower is going to send that interest payment to Advanta each month. Just send it directly to our office, made out to Paul's IRA account, and then we will deposit it directly into his IRA. And Paul can track that monthly statement or monthly payment using his online statement. We have online access. You can go in, make sure that those payments are being received on time, and if necessary, if they're not, making sure that his borrower next month sends a late fee or whatever else he may have arranged within that note and mortgage. So when that mortgage pays off in a few years, if the borrowers decide to sell, his mortgage gets paid back its principal. Certainly there's no taxes due on that. And then also, because all this is done within an IRA, all of that accrued interest over that 3-year period also comes back into the IRA tax-free. Our next transaction, we have Andrea, who is interested, maybe not in being more as passive as Paul was as far as just lending the money out and letting someone pay back an interest rate. She's actually out there looking for deals that people are doing and looking to get in on part of it, but maybe not actually being the individual responsible for fixing up the property. So she's looking at joint venturing. She has about $100,000 invested in mutual funds, but really figures that better returns could be utilized and gained by working in the real estate industry as opposed to stocks and bonds. Andrea meets Steve, perhaps at a local real estate investment club or just through some friends. Steve is looking to flip properties. He buys properties, gets them fixed up, sells them, makes a healthy or decent profit on each deal. He's always in need of capital. He has more deals than he finds more deals than he can actually fund. So Andrea, again, performing due diligence on Steve and the property that he's looking to flip. It's very important that she is analyzing that deal, making sure that Steve is reputable, and also making sure certainly that whatever he's proposing to her makes sense. And so, after looking at the property and talking with Steve and looking at what he has in mind, she offers to lend him $100,000, and this is kind of how the loan shakes out. $100,000, she charges only a 5% interest rate, which for investors, certainly with rehabbing a property, is a very low interest rate. But she's also going to ask for 1/3 of any profit. So any amount that this house sells for above $100,000, she's going to get 1/3 of that back to the IRA in addition to that interest rate. There's a 2-year balloon on the note, and so that monthly payment, for Steve at least, is a low $420 a year. And Andrea also gets a first mortgage on the property. So if Steve doesn't finish what he started or doesn't perform, she can at least foreclose and take the property back and get at least part of her investment back. Andrea's attorney is going to prepare the note and mortgage, and again, she's going to review and approve all documents that are sent to us. In the case of a joint venture or an equity participation like this scenario, it is important to Andrea to make sure that the wording that's being used to calculate the profits, how they're to be split, everything like that is drafted correctly, and that's why we do encourage you to use an attorney or someone at least very familiar with drafting those types of documents. But once she approves them, sends us the purchase authorization form, we ultimately will send the funds out for that investment. 6 months later, Steve is ready to sell the property for essentially a $30,000 profit net after the closing costs. He requests the payoff amount, and Andrea will probably work with us to get him that figure, whatever it would be for the actual mortgage. So the title company handles the closing. Basically, the money comes back in. She certainly gets her principal back of the full $100,000. She had some monthly payments that totaled $2,500, as well as that 1/3 of that $30,000 profit coming back. So on $100,000, she returned basically 12.5% over a 6-month period of time. And certainly these numbers could fluctuate and could depends obviously on what the profits were to really see if this made really good sense for Andrea to do. So again, it's important for the client to look over the investment, look over the person they're dealing with, and decide if something makes sense. But in this case it did, and it worked out great for her. And if you look at the perspective from Steve, it wasn't his IRA account, but he still was able to make $17,500 even after paying any loan, the repayment of the loan, any interest, any profits, etc., back to her IRA account. So if you're someone who doesn't have an IRA account wondering how can self-directed IRAs, if I don't have an IRA, why do I need to know about self-directed IRAs? Well, here's a reason. If you're a borrower and you're someone who's always looking for additional sources of capital and you have people who may be willing to lend to you, their IRAs can actually be a great resource for you in borrowing those funds. Now again, kind of just to revisit, stop for a moment and talk about the collateral issue. Again, having your note, the last two examples, the note was secured by a piece of real estate, which again, an IRA is perfectly possible and legitimate for an IRA to own real estate. So if Andrea or Paul in those examples had to foreclose on their borrower, they could have held the real estate within the IRA. But if you're holding something as security, like life insurance or some type of collectible, it could make collection of that debt difficult. It's not per se prohibited because, again, the investment is I'm lending money from my IRA to a third party. It's a loan. That a loan is not prohibited. The third party is not disqualified. But if the security for that loan is a collectible or some other type of asset, could make the collection very difficult. One thing that's kind of also neglected at points, certainly the collectible issue, if it's an automobile or some antique, that's pretty clear that that's collectible and could pose a problem. But also we've seen some investments made where an IRA lends money to a business and the business secures that loan with stock. So if they don't pay, you actually get stock in the company. If that company is an S corporation, you'd have the same kind of issue for an IRA. S corporation, the rules for S corps require that all owners be individuals, not IRAs or other entities. So if your IRA loans money and it's secured by S company, stock that is in an S corp, your IRA couldn't hold that stock if you had to foreclose. You'd kind of be stuck in that same kind of issue. Also, kind of something to think about is if you're using something other than real estate as collateral, how does that security agreement look? Where is it recorded? How are people put on notice that this asset is collateralized? If you invest in a first mortgage on a piece of property, it's very clear in the public record that the property, before it can be sold, the mortgage has to be satisfied. When you're doing things like company stock or just other assets, how do you really properly secure your IRA interest? You could probably use a UCC filing or something like that, but it's important, again, to make sure that you think about these things before you do those transactions. The next case study is for an unsecured note. It's pretty simple. Tom has a SEP IRA looking to just invest possibly as a close friend he feels a little more comfortable with. So he decides to lend without any collateral. The promissory note would be drafted listing Tom's IRA as the lender. And in this case, the terms are it's a $50,000 loan. He's going to charge his friend 10%. Payment at the end of that 1-year balloon is just a lump sum amount of $55,000. So he earns 10% on his money in a year, when his friend pays him off. So again, kind of the illustration of this note as well is just the flexibility in terms. In our other examples, there might have been monthly payments, or you could have quarterly payments. And in this case, it's just simply one lump sum payment at the end of the term. Whether it's a 1-year balloon or 5-year balloon is up to you and your borrower to determine. Some considerations on the unsecured lending. Typically with an unsecured note, there is not going to be any type of title company or third party handling that transaction. So because there is no company making sure everything gets signed correctly, we require to receive the original signed note in our possession at our office before we can release any funds. It'd be dangerous for us to actually release funds in hopes that we eventually get that note signed. If a title company is involved or some other third party, we could send money to someone's escrow account under the condition that those funds aren't going to be released from escrow until all the appropriate documents are signed. That's typically what would happen with a mortgage note. But since an unsecured note doesn't have that and typically doesn't go through a title company, we do need to get that original signed note prior to the release of any funds. Usually unsecured notes have a little bit higher interest rate. It's riskier, so the premium goes up on borrowing those types of funds. An example here is to see credit cards. Credit cards definitely have a higher interest rate than a typical mortgage would have from a bank. And again, make sure you know your borrower. Having to collect on a private unsecured note could be very difficult, if not sometimes impossible or not available. If an individual borrowed money from you and just signed an unsecured note, that individual declares bankruptcy, there might be a long list of creditors that have priority over your unsecured note. So again, it's very risky, so make sure you know who you're dealing with before making that type of loan. Here's another example. It kind of has a little twist to it. In this example, Jim, rather than doing a note off the bat with his IRA, actually is experienced and looks at buying foreclosures, getting them fixed up, and then reselling them. So he's actually able to acquire a property at foreclosure for $40,000 within his IRA. So again, his IRA is the actual purchaser of this property. The IRA then pays the $10,000 to get the property fixed up. Then he's out there looking for an end buyer, and typically he'd probably be happy if he could unload this property to someone else for cash and just be done with it. But he also entertains the idea of sometimes of seller financing and having his IRA actually finance the purchase for a third party. And in this case, he finds an end buyer who's willing to pay $80,000. They're going to put $10,000 down, and Jim's IRA will just kind of swap out the real estate and hold a $70,000 note instead. So he's bought the property for $40,000, put another $10,000 to fix it up, selling it for $80,000, gets $10,000 down, and then holds the $70,000 note. It's an 8% interest with a 15-year amortization. He's getting a monthly payment of $670 back into his IRA, and again, securing this note with a first mortgage on the property. In the seller finance deal, again, Jim is going to buy the property at foreclosure, get it fixed up, have the IRA make all those payments for those repairs. His IRA gets that down payment. So basically, he gets back his repair costs back to the IRA, and then finances the balance of the purchase with a note for $70,000. Kind of what does Advanta do in this transaction? We process that initial purchase. We certainly have sent the checks out for repairs, process the paperwork for the sale and the carryback, make sure that the vesting on all of the documents, both the acquiring of the real estate, then the selling of the real estate and the acquiring of the note, make sure that is all in the name of his IRA. And then eventually the borrower is making payments back to his IRA. We're receiving and depositing those into the account. So the net result of his deal is he ends up with monthly cash flow back to the IRA. He's getting that monthly mortgage payment, has no expenses, doesn't have to keep up the insurance, the taxes, the maintenance, because it's that's now on the backs of the new buyer. Essentially, he's getting almost a note purchased at a discount. He paid $40,000, and at the end of the day, receives a $70,000 note within his IRA account. All right, one of our kind of switch gears here, and again, we've talked so far about the IRA making loans to third parties. We'll talk now about specifically an IRA buying property and using financing, actually having an institution lend money to the IRA account. So the IRA is the borrower instead of the lender, as we've been speaking of. In this case, Mike has a former 401k, interested in buying, a short sale, a single-family home. Figures he's got some long-term growth potential. He's getting a good deal on it now. It's going to be a good rental property as well for him. So he's got $75,000 in the account, but the property he's looking to buy is $100,000. The good thing for him is it doesn't really require a lot of work. It's almost turnkey. Probably get by with putting just $1,000 or $2,000 or so into the house, get it ready to rent. So he decides to use some money from his IRA as a down payment and finance the rest of the purchase with a non-recourse loan. So he's going to put up 50, basically put 50% down for this note. Now, with the way the IRS rules work, you cannot personally lend your credit for the benefit of your IRA account. So in getting this note, the bank has to issue a non-recourse loan, meaning that he cannot, as the IRA owner, cannot guarantee that note personally. The non-recourse means the bank has no recourse against Mike or his IRA for non-payment. They can't go for any additional cash. They can only foreclose on that property. The non-recourse loan is actually to the IRA directly, and the IRA repays the loan out of the cash in the account. So a representative from Advanta is actually going to sign on behalf of your IRA on that promissory note or on that mortgage. The individual IRA owner, in this case Mike, will not sign the note and promising to pay. If you were to do so, it violates the IRS rules. Typically, the lenders that do this type of deal want 40 or 50% down. Sometimes 30 to 40, depends on who you're working with. But they also want to see some cash in reserve, and they want to see that it's an income-producing property. Any income received on this asset, though, is subject to what's called unrelated debt financed income. It's one instance in which an IRA can actually potentially owe a tax on returns received. In general, an IRA, for all the examples we've been talking so far, gets back interest income back into the IRA. There's no taxes due. That's just tax-free gain to the IRA. But when you use financing to purchase property, the income you receive is subject to a UDFI tax. Now, the UDFI tax is based on the percentage of financing. So if you, in this case, Mike had 50% down, 50% finance, so 50% of the income is subject to the UDFI tax. Now, the percentage, as that non-recourse loan gets paid down, the percentage of financing is going to go down, meaning more tax-free revenue back into his IRA account. Now, if UDFI tax is going to apply, the IRA actually will file Form 990T, which is an IRS form typically used for churches and universities to file their business income that they receive that's unrelated to their tax-exempt status. But the IRA files a 990T, and the IRA can deduct expenses and depreciation to offset the tax implications of UDFI. In most cases, an IRA doesn't take depreciation and deductions because it's not paying tax on any of the income generated. In this situation, the UDFI, with UDFI, you can take expenses and depreciation to reduce that tax liability. It's actually, if there's no 990T, no tax return is even necessary if the UDFI liability is less than $1,000. And this tax, the 990 under UDFI, is paid at trust tax rates. And this, the loan details, this is taken from a recent example we had, kind of showing you what the typical interest rates and terms are. So in Mike's example, he's put $50,000 down. He's needing to borrow the other $50,000 to complete the purchase. It's a 7% fixed rate loan with a 20-year amortization schedule. So he has yearly payments of around $4,600 a year that his IRA is going to actually have to make out of that account. So rental income will come into the account. The cash that comes in can be used for expenses, upkeep, but it's also the IRA is going to have to make this monthly mortgage payment. Kind of a quick and easy explanation of UDFI. I would definitely recommend talking with a CPA to get a much more detailed analysis. It's not quite as simple as this slide demonstrates, but kind of just gives you an idea. Okay, Mike had a $100,000 property. He's renting the property for $900 a month. His total monthly rents over the year are $10,800. Now, the total rent that is subject to UDFI will be $5,400. The other $5,400 will go back to his IRA tax-free. That's kind of his equity portion. he would not be subject to UDFI. So $5,400 of his total rents are subject to UDFI. Now, if you use the top-end tax trust tax rates of 39%, he's going to have to pay $2,106 in taxes, or his IRA will have to pay those taxes each year, which means his net income for that portion will be about $3,300. So the total income, the total monthly rents minus the taxes, he's looking at around $8,700 a year back to his IRA account. So it's 8.7% basic return to his IRA. Now again, this example does not include the deductions and depreciation. It also doesn't take into effect that the tax rate may not be 39%. So his actual taxes paid may end up being much lower, which would then basically just increase his bottom line to his IRA. That concludes the presentation. For more information, you can call me at 727-581-9853 or just email me. My email address here on the last slide. I'd be happy to take any questions by email or phone at any time. You can also visit our website at advantairagroup.com. For other upcoming events, live seminars that we have, our education that we offer is always free. So I appreciate you watching today. Thank you.
Thank you. Please stand by.